Hi, I'm attorney Dan Marusak with Greene Marusak, and today I'm with my partners, Courtney Ross and John Greene, and we're going to be talking about the claims process and specifically what forms you're going to file throughout the claims process for VA benefits. So, Courtney, let's say a veteran wakes up one day, never filed a claim for service connection before with VA. What's the first thing that they should do?
The first thing they should do is file what's called an intent to file, and it's VA Form 20-0996. That basically secures the effective date from that date that the form submitted. And you have 1 year from the date of that submission to submit an actual proper claim form.
Okay. And John, what's the proper claim form that the veteran should file? Again, if they've never filed
a claim before, they're going to want to file the VA Form 21-526. It's a fairly lengthy form, everything ranging from contact information to disabilities, treatment, anything that's going to be helpful to VA to make a decision on a claim. But even if you're going to be filling it out, you don't know all the information, you want to get that 21-526 in.
Yeah, the key thing is just getting a claim filed. Like, get the intent to file in, gather what evidence you can, but if you're coming up on that year deadline, just get the claim rolling, get that 526 easy in, and get it started. You'll have time after you file the claim to submit additional evidence. VA is probably going to call you for examinations after that. So you have plenty of time to add to the record before they make a decision. So the veteran filed the intent to file, got his claim in within a year. VA is going to send it to some exams, and now the veteran gets a decision. Say there's some grants in the decision, there's a couple denials, the veteran's not happy about their ratings. What are the veteran's options at that point for next steps on the appeal?
Yeah, so the veteran has really three options. They can file a notice of disagreement to the Board of Veterans' Appeals, and that's one specific form. They can file what's called a higher level review request, which is on another specific form, or they can file a supplemental claim, which is on a third specific form. And each one of those has to be filed within 1 year of the decision that they received.
Okay. All right. So let's say the veteran chooses the supplemental claim route. Why would the veteran pick that, and what form are they going to use?
So a supplemental claim would be a good option if there's any additional evidence that they want to submit in support of the denied issues, or if they're seeking a higher rating. The supplemental claim route allows you to submit additional evidence that VA will have to consider. And the form that you would need to submit is the VA Form 20-0995.
Okay. And John, if the veteran instead decides, I don't have anything else to submit, how about a higher level review? What would that form be, and why would the veteran choose that?
So the form is, for higher level review, is the 20-0996. That's the form that you kind of want to submit if the decision, they just got it wrong. You don't need to submit any new evidence to establish a nexus or to establish a diagnosis or anything like that. They just got it wrong. You need to have an opportunity to have somebody who's quote unquote higher level to review the case to get it right. You file that higher level review form. I wanted to note that within that form, you do have the option to select to have an informal conference with that higher level reviewer. It's a good opportunity to speak with the person who's going to be adjudicating your case and kind of explain to them why they got it wrong. And oftentimes these experienced people are going to recognize and know what you're talking about and hopefully issue a decision that is going to be favorable.
And just to step back to the supplemental claim for a second, there's the new and relevant evidence requirement, right?
Yes.
And you can also use a supplemental claim after a year, right? So the year deadline doesn't apply necessarily to supplemental claim?
Correct. So if it's an issue you've applied for before, it's been denied, the 1 year passes, and you want to file for it again or continue to seek that issue, the supplemental claim form would still be the correct form to use. The difference is the effective date for any potential future grants. If it's outside of the 1 year period, it wouldn't necessarily go back to the initial claim. It may only go back to that new supplemental claim date.
So it's in your best interest to get an appeal in, no matter what it is, within the 1 year deadline after the rating decision.
Exactly.
If not, you can always file a supplemental claim after a year with new and relevant evidence. Okay. So say the veteran gets another decision after the higher level review and it's still denied. John, what would you recommend at that point? What forms are available to the veteran?
So if you try the higher level review route because you would be maintaining that they got it wrong and that higher level reviewer, in your opinion, still got it wrong, then what you can do is go to the board, which is essentially a higher level reviewer. Same deal. You got to get that NOD filed within a year. And in that NOD form, the 101A2, you have three options, basically. You have the direct review option, which is essentially the same sort of, process or, same sort of idea as the higher level review, where you're just moving forward with the evidence already of record, saying, again, they got it wrong. So that would probably make the most sense when you're going off of that higher level review denial. Do you want me to get into the other options?
Well, a couple things to note. NOD stands for Notice of Disagreement, right? So you're disagreeing with that prior decision. The other thing is that after a higher level review, you can't file a higher level review again, right? You're stuck either going to the board or the supplemental claim route again with new relevant evidence to get another decision. So your choices are really either supplemental claim route, staying at the regional office level, as we say, for a rating decision, or taking it up higher to the board. So Courtney, why don't you get into the three lanes at the board? So the veteran chose to go to the board. They know they're going to incur a bit of a weight no matter what lane they choose at the board. What are the three options for the veteran?
Yeah, so there's direct review, the evidence docket, and the hearing docket. And the difference between them really is with evidence submission rules, and obviously the hearing docket offers an opportunity to have a hearing. The direct docket, you cannot submit any additional evidence after the date of the decision that you're appealing to the board. So if you do submit any additional evidence and you select direct docket, the board doesn't have to consider any of that evidence. The evidence submission docket or the evidence docket gives you 90 days from the date that you filed the NOD form to submit any additional evidence you want the board to consider. And then the hearing docket gives you an opportunity to have a hearing with the veterans law judge at the board. That docket is where you're going to wait the longest for a decision from the board.
And you select which lane you're going through on the 101A2 form? Yeah, correct.
Exactly, yeah. So it's the same form, no matter which docket you choose. There's just an option on the form, and you check the box.
Okay. And quickly, John, are there any benefits to each lane time? One of the biggest concerns for veterans is how long they're going to wait at the board. Can you speak to that at all about the different lanes, kind of what we're seeing?
Yeah, generally speaking, if you can avoid the board, avoid it. No matter what lane you choose, it's going to be a wait. It's going to be measured in years and not months. Direct review lane, no new evidence of record, nothing new for them to consider. That's going to be the fastest option. You're still looking at, in my experience, a few years before you're going to get a decision there. Evidence lane, where you're providing new evidence for them to consider, add on probably another 18 months at least before you get a decision to what you would have had in direct review. And then the hearing lane is probably the longest. That's where you get to have an actual hearing, either in person or on video, with the veterans law judge. Some veterans really like to have sort of their quote-unquote day in court and select the hearing lane. In our opinion, we really don't feel that the pros outweigh the cons with the hearing lane because your case is going to be parked forever. So that's, usually where we send. If you need new evidence, get the evidence in. Otherwise, argue your case in the direct review lane. Avoid the hearing lane altogether.
Great. And so the veteran waits 2 to 3 years, whatever it may be, and they get a board decision. It's unfortunately a denial. What are their options, Courtney, at this point?
Yeah, so they have two primary options at that point. They have 120 days to file an appeal at the U.S. Court of Appeals for Veterans Claims, or, assuming it's a decision in the appeals modernization, it's an AMA decision in the new system. They also have the option to file a supplemental claim in response to that board decision within 1 year of it. And as you noted before, even if you're filing a supplemental claim at that procedural posture, you would still be required to submit new and relevant evidence.
Right. And so also the higher level review, again, is out. So you can't higher level review a board decision. Right. So, and if the veteran chooses to go to the Court of Appeals for Veterans Claims, there's a whole set of forms required there that are dictated by the court rules. So that kind of takes us through all our procedural forms or appeal, forms necessary for an appeal. There's also other forms that a veteran may encounter or may be helpful for their case. John, can you talk about the 686C, the dependency form, and what that asks and why a veteran will want to file that form?
Yeah. So when VA finds your disabilities to be service connected, they're going to assign ratings. If your combined rating is 30% or higher, the amount that the dollar amount equating to each percentage is going to be different depending on the number of dependents that you have. So the 686C should get filed to essentially inform VA that, hey, I have these dependents, I have a spouse, I have these dependent children, and that's going to be used to determine your monthly compensation amount. So once you're service connected, be thinking about getting that 686C form in. Certainly get it in after you're found to be service connected and a disability rate is 30% or higher.
Yeah, I don't know if you mentioned that, a year to do that, right? To get an effective date back on the dependency credit. So, yep, it's important for retroactive benefit purposes. And Courtney, how about the unemployability? If a veteran's seeking TDIU, total disability due to unemployability, what form would the veteran need to file there?
Yep, so they would need to file with the VA Form 218940. It asks specific information about the last 5 years of the veteran's work history, questions about their education or prior experience in professional certifications, as well as personal information about where they treat and their identifying information on that form.
Okay, so after the veteran files the 8940 form, VA is probably going to request a couple other forms. What are they going to request?
Yes, the two most common ones are the 4142 and the 4192. So the 4192 deals with employment verification. It's essentially a request to the employers that were listed on the VA Form 218940, asking them to verify the dates of employment the veteran works there. The 4142 is a medical records release request. So it's essentially allowing VA, it's giving them authorization from the veteran to request medical records from the treatment providers that were noted on the VA Form 2189.
Mm-hmm. Okay. And there's VA has a form for everything, but a couple other ones that a veteran might encounter is the 210781, which is a PTSD stressor form. What can the veteran expect to have to answer on that type of form, John?
So, unlike other mental health diagnoses, PTSD, VA requires that there be a confirmed stressor, and the 781 form is really just the veteran able to put into their own words what happened, where they were at, anything that can help VA see if they are able to verify that this stressful event did occur.
And then the 214138, which is a statement in support of claim. We see that used often as well, Courtney. Mm-hmm. We'll speak to that.
Yeah, so it's a general form that really the name of it speaks for itself. It's a statement in support of the claim. So it can be used for any claim that a veteran has, whether they're filing it. It's a new claim they're filing, or it's something that's already pending with VA and they want to submit a statement specifically speaking to something that's pending. They can use that form kind of across the board anytime they want to submit.
Do they need to, if they want to submit a statement, or they have a spouse or a battle buddy submitting a statement, does it need to be on that form?
It doesn't need to be on that form. You could draft something up separately in a Word format or PDF format. But there is one benefit to using the form for the statement, and that it often catches VA's attention in the file, sometimes easier because it's labeled as such.
Great. Well, that's all we have for today. Thanks for joining us. If you have any questions about what form you should be using, reach out to an accredited representative like us at Greene and Marusak. Have a good day.